Well, your family's always number one, Brisbane's 96.5. It is Ilya. This is interesting. 50%. That's right, 50% of Australians don't have a will. Some interesting sums there. Maria Linkenbagh joins us from Dynamic Law. Good morning, Maria.
Good morning.
50%. Now, is this right?
Well, it's hard to say because, there's no accurate counting mechanism, but from my years of experience as a solicitor, certainly there are many, many people who don't have a will and people who only make a will or think in terms of making a will when there's some large event coming up in their lives, such as the birth of a child or getting married or buying a house or acquiring assets of one sort or another.
Now, Maria, apart from the obvious reasons, why should we have a will?
Well, it makes things simple for the people you leave behind. That's the main reason. Whatever your family circumstances are, and these days with blended families and so on, there can be complex administration issues involved in the administration of an estate. If there's a will, it spells it out. People who left behind know what the testator or the deceased person wanted in relation to their property, their children, and, provision for those who are dependent on them in some way.
Now, I'm a fan of cats myself, and some of the guys here at work are. Can you actually leave things to your animals, like your cat or your dog?
Unfortunately, in Australia, you can't do that. I think you can in the United States and some countries overseas. But a cat or any animal is not a legal person. A legal person is a human being or a corporation of some kind. So the cat doesn't qualify as a beneficiary under a will. You can make provision for the care of your pets by leaving a sum in trust to be administered by your executor or trustee to pay for the expenses relating to the pussycat, but not to leave the cat to the cat themselves. I mean, how's a cat going to pass on a couple of $100,000?
Exactly.
He can't make a will.
I'm sure he could eat the food, but that's about it.
Yes, but the pets can be looked after.
Maria, how easy is it to actually do a will? Is it complex?
It can be. The hard part is the decision-making by the testator, him or herself, in deciding what they want to do. It's important to dispose of every part of your estate, all your assets, so you give any specific gifts, and then at the end you put in a catch-all to say, well, anything else that I haven't given away, I give to my residuary beneficiary and name the beneficiary. The advice to people is to focus on the need to make a will and use the process that's appropriate to them.
Would you like to see the Australian population, I guess, with the fact that we've got 50% that don't have a will, what would you like to see happen in the next few years?
I'd like to see people to become more aware of the need to make a will and to think in terms of, a lot of people think, want to put off making a will because they don't want to think about dying. But you can skip that bit and you can just think in terms of making life easier for the members of your family who are left behind. It's like organising anything. People, particularly as they get older, should be educated to make a will, to have a power of attorney so that if something goes wrong with them, there's somebody around to look after their affairs, and also to appoint a guardian to look after them if they happen to lose their capacity to make decisions for themselves. It's a matter of organising your personal affairs, and I'd like to see that over the next couple of years there be a great emphasis, a public emphasis on getting your house in order, so to speak, just in case the worst happens.
Yes, some good advice. Maria Linkenbagh from Dynamic Law, thank you so much for joining us.
Thank you.